only procedure the HOA had was to go to court to enforce its rules. Does that answer your question?
Well, partly, I guess. I mean, if you raised the issue of the affidavit with the court last time on appeal, and it was dealt with.
Well,
Wasn't that the end of it?
it was not really dealt with. At that time, this court said nobody knew exactly what the compulsory counterclaims were. Judge Binkley's his injunctive relief and declaratory relief. But if you read Judge Binkley's final decision, that's not even possible.
Well, we never really got to that, did we?
Exactly. Couldn't get to it because we never got to that part of the case.
Well,
It was interlocutory.
well then how can you say the affidavit's false if that part was never really gotten to?
Oh, it's gotten to now, though.
Well,
What I'm trying to say is, if Judge Binkley's final decision after reading the CC&Rs is that the HOA was acting ultra vires, there can be no compulsory calculations. There's no damages in the CC&R for him to swear to. That's why see, the decision made before was before the court ever got to a determination that the CC&Rs didn't encompass damages. There's no place to get what he was swearing to.
okay.
Again, Mr. Fowler only argued he didn't argue that he changed his mind. He argued that he was arguing Rule 11 sanctions, which was not even relevant because Rule 11 sanctions wasn't even sought. It was inherent authority sanctions.
Well, Rule 11 is the way you're supposed to seek sanctions when someone makes claims that you feel are inappropriate. You inform them under Rule 11 that they are inappropriate claims, and if the person pulls back on them, then it goes away. But if they don't pull back on them, then sanctions are possible if the court finds that they are.
Well, I found that that's not true in Tennessee. Inherent authority sanctions are always available, even if he withdraws.
I think when the Supreme Court tells you in certain situations this is what you do, that's what you do if you're a lower court, So Rule 11 is a viable rule, and it wasn't invoked when it should have been, or at least possibly should have been.
There's no way to invoke. How could I invoke Rule 11 5 years into the court? The case has already been established in 20. We couldn't even invoke Rule 11 on day one because you didn't have determination. Judge Binkley didn't get to his decision until 5 years later.
Right.
Therefore, there's no way to have Rule 11 sanctions that already passed. That's
Okay.
history. History has already gone past it. And also, inherent authority is always available to a court.
I don't want to take all your time, so keep going.
Also, Judge Binkley was incorrect. Like I said, this is 5 years in the making. The courts all relied on that affidavit. That's what got us to this point. If Judge Binkley had read the CC&Rs in day one, or if Mr. Fowler had not gone to General Sessions Court and made the false affidavit, this case would have been resolved in General Sessions Court. And it's clearly reckless to file a false affidavit, and it's clearly bad faith to delay a litigation, because I don't think Mr. Fowler was ready for General Sessions Court. The second sanctions we're looking at is dealing with Mr. Cole, who represents Judge Binkley. And clearly, Judge Morgan abused his discretion by not finding that Mr. Cole was reckless and acted in bad faith when he filed a motion for a second final order. Mr. Cole, basically in his briefs, even in his arguments, admits that he filed the motion without knowing the status of the case. That, by definition, is reckless.
Well, it was certainly a mistake, but he didn't know the status because he hadn't been sent the final order, right?
Oh, that would be, well, I got two problems with that. If he's representing the judge, how would he not know what the judge has already issued a final order? And two, who authorized him to file the second order if it wasn't Judge Binkley? Judge Binkley's the one already given the final order. If final order is a final order, if they thought the final order wasn't final, then there had to be an interlocutory order. It wouldn't have been considered final. Two, they won. He tells you he won and was successful in not getting Judge Binkley added to the case. So then why would he need a second final order? They already had won. Two, who was he writing the final order for? The final order, the motion clearly didn't have a hearing date. And I don't know which court he was writing it to, because as he had said, Judge Binkley couldn't hear his own, something that was regarding himself. Therefore, who was he writing it for? And there was no concrete dates or anything. It was like an open-ended motion for a second final order. Two, and third, the second final order is not even legal. There's no place for a second final order. So I don't understand how he would not know what his client was doing, and how his client didn't authorize him to do what he did and not tell him what he was doing. It was like only 2 weeks prior to the filing of the second final order that he issued this motion. The third sanction is regarding what I call an unauthorized practice of law, technically. Judge Binkley abused his discretion regarding Mr. Fowler's unauthorized response to a motion for sanctions regarding the second final order that we were talking about.
Okay, Mr. Fowler suggested that it was unclear as to who that was aimed at, and he filed the response out of an abundance of caution.
There's no need for an abundance of caution.
I think when you practice law, there's always a need for an abundance of caution.
Well, the problem is, I was very specific in the filing of the motion. The motion tells you which filing was. It says the docket number. Mr. Fowler didn't write it, had nothing to do with it. If you want to truly be an abundance of caution, his answer should have been, out of abundance of caution, I'm responding to this and telling you that I didn't write or have participated in this motion. Therefore, I have no reason to feel like I'm susceptible to the sanctions. But he didn't do that. He didn't argue for himself. He was arguing that Judge Binkley has immunity. Well, Judge Binkley has an attorney. He can't represent or make arguments on behalf of Judge Binkley. Again, Mr. Cole is the judge's attorney. The motion was very specific. I listed the docket number, and another part of it that gets lost in this is Judge Binkley didn't have jurisdiction, because this motion was actually should have been before Judge Morgan, because that's where we had the hearing regarding this, the rule regarding the second motion for the second final order. Again, it fits under the unauthorized practice of law under TCA 23303. He had no right to represent. He had even withdrawn. This court here had granted his withdrawal from the case, so Mr. Fowler was representing absolutely no one regarding this matter. And it's very reckless, as the definition would be. Recklessness would be defined as a conscious disregard of a substantial risk or a failure to exercise the care that a reasonable attorney would under the circumstances. Mr. Fowler, again, the motion had nothing to do with Mr. Fowler. Mr. Fowler didn't have any reason to make any statements, especially regarding Judge Binkley's rights. As such, I'm moving that the court reverse both the judge's decisions regarding denying the motion for sanctions.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors.
Good afternoon.
Chris Fowler. I'm joined today by Jonathan Cole. Mr. Cole represents Judge Binkley. I suppose I represent myself along with my law firm, even though they're not necessarily named in the appeal. They were named throughout the pleadings. If I could reserve, please, or to divide my time, if I could have 12 minutes and Mr. Cole have 3.
12 and 3,
Yes, Your Honor.
that'll be fine. Go ahead.
Yes, Your Honor. And thanks again for hearing us today. I'm sure the court's aware of the past of this case, the thousands of pages that have been filed. There have been 8 initiating documents to get this case on appeal. I'm going to go through each argument individually, but as the court has already pointed out, many of these issues have been ruled on. They're about parties that have already been dismissed, or they are part of an order that has become final. The singular issue that the appellant brings in this case is whether or not he's entitled to some type of a sanction, because I responded to a very vague motion that he submitted that we now know was against Judge Binkley. I thought it was against Judge Binkley, but in reading his motion, just like in reading this appeal, it was unclear who the target of the appeal was to go towards. To take Mr. Burgess's arguments here, he argues that I have no standing to file papers or respond to motions, but if I do respond, I should be sanctioned, and if I didn't respond, I should be found as losing some type of point of law, almost like a default judgment, which is exactly what has happened throughout this case. It's gone on almost 5 years. As Judge Bennett pointed out, every other issue was handled in detail in the order that was entered by this court back in January of 2022 or 3. Again, it's a long case.
So, concerning this response that Mr. Burgess said was improper, you responded why?
I responded because it was not totally clear to me whether or not that motion was directed to me. And as I cited, as I discussed with Judge Morgan during the hearing with him, the record, there's a transcript, it's volume 11. There's no Bates numbers on those pages, but Judge Morgan asked me the exact same question, why would you respond? And I said, I was afraid that if I didn't respond, then he would be seeking some type of a judgment against me. But that was it, and that was the whole. And I immediately said, Judge, if it's not at me, I'm happy to withdraw it or strike it or whatever. I just wanted to make sure that I'm not going to be dinged on this for some reason out there. I think it's also worth.
So you filed the response on your own behalf, not any Judge Binkley's, for example.
Correct, Your Honor. And I will admit, in my response, I made a passing comment that said that Judge Binkley was immune from the things that Mr. Burgess was seeking against him, just like I'm immune from the things that Mr. Burgess is seeking from me. Between litigation immunity and judicial immunity, these are points of law that I don't know what Mr. Burgess seeks to have happen from me writing a 1.5-page response, throw off just saying, please don't find a default judgment against me for this motion that was filed. I did not represent Judge Binkley at the time. I do not now. I will say that there were issues with filing through no fault of anyone, but having Judge Morgan appointed as a special judge and not being connected to the clerk's office, and there was just at times there had been a bit of a break in communications. But again, this transcript of the hearing with Judge Morgan, he says, look, I don't always get everything. If you can explain to me what's been filed. And then he goes on to say, thanks to this discussion, I now understand why you all are here. Said, Mr. Fowler, I didn't know why you were here because you're not a party. And I'd actually withdrawn from this case back in March of 2023. The only reason I was still present was because there was this pending issue of whether somehow I should be sanctioned. And that's why I was on the call.
So that gets to the other thing that that Mr. Burgess raised. The false affidavit regarding the transfer, false in quotation marks,
Certainly.
regarding the transfer from General Sessions to Circuit. You never really had to explain the reasons for that, you know, your good defenses and everything, because we never got that far. Is that right?
That's exactly right, Your Honor.
It seems to me, and I'd like your thoughts on this, that Mr. Burgess is seeking a second bite of the apple with regard to this. He tried to get you sanctioned initially, and he didn't follow Rule 11, so that was tossed. And now he's seeking it under the court's inherent authority, as I understand it. Is that right?
That's exactly how I understand it, Your Honor. The affidavit that I wrote, like I said last time I was here in front of you all, there was a comma. I'll admit it was out of place, but this record, if any record has vetted itself out, has been complex. It did have defenses that were raised, and funny to come back to the point of what Mr. Burgess was seeking was a declaratory judgment, which is ultimately the claim that he succeeded with in front of Judge Binkley. Again, 8 appeals and however many thousands of pages and motions, and the docket report, I think, is 33 pages long. This has been an absolutely complex and just extended litigation. And again, I didn't file a countercomplaint or the counterclaims because A, we hadn't gotten to that point and it wasn't appropriate for me to file those things. And B, I was asked to withdraw once any of the tort claims had been eliminated, and the only remaining viable claim was for declaratory action, and that's a claim that was not insured, and so the insurance company cut me out. That's cited, it's in the record, but it, for whatever reason, didn't make it in the technical record, so I don't have a Bates number for you on that, but it's anyways, it's in the record that I filed with the motion to withdraw with this court and with the trial court.
Okay. In your position, I gather from what you said at the beginning of your remarks, is that was something that was dealt with before, and it's really not proper to be before the court now.
Correct, Your Honor.
Okay.
And again, out of an abundance of caution, Mr. Burgess's appeal raises 9 issues. I did my best to go through those 9 issues and specifically say, here's why this either doesn't apply to me, here's why it may apply to me, but it's already become a final order, or here's the one issue that actually does apply to me, and here's why I should not be sanctioned. And the reason why I should not be sanctioned is I have done nothing in this case that's sanctionable. I've made plenty of mistakes in my life. This case is not one of them. That affidavit is not one of them. I've done nothing to Mr. Burgess that warrants sanctions against me. I don't know what else to say. That same conclusion has come from multiple different courts, multiple different judges, from this court as well. We're now sitting here talking about, with the 3 of you sitting here, 2 attorneys defending it. There's a lawsuit that's been going on for almost 5 years with no merits of the case remaining because all of the parties have been dismissed. And the sole issue is whether we should somehow owe sanctions for withdrawing a motion to a vague, removing responses to a vague motion filed by Mr. Burgess. To the extent that I did not directly address any of those 9 issues, and as I said in my brief, any issue raised by Mr. Burgess is denied and explicitly defended against. Again, it's difficult to respond to the appeal and the pleadings in this case because, as I started, I think I'm here to only represent myself, and we all know what it's like to have yourself as a client, but I also think that on some level I am representing my law firm as well because as a group, were targeted before. Again, I'll just close with, there's nothing false I've said in this case that was not in passing or was just a mistake of some minor detail. I made no lies to the court. Again, nothing sanctionable here. In conclusion, judges, just asking the court to affirm the multiple trial courts that have ruled in this case, ask you to deny and dismiss Mr. Burgess's appeals and to assert and assess any court costs against Mr. Burgess. And I'm happy to answer any questions you may have. All right, I'll concede
Sure
to
enough.
Mr. Cole. Thank you.
Thank you. I believe you have, was it 3 minutes?
Yes, Your Honor, that's fine. Good afternoon, Your Honors. My name is Jonathan Cole. I'm here on behalf of the Honorable Joe Binkley, who's a circuit court judge here in the 20th Judicial District of Davidson County. Your Honors, we believe that this matter should be dismissed. The rulings of Judge Morgan should be upheld. It's a little unclear, frankly, from the pleadings of the plaintiff, Mr. Burgess, and then through his argument here on if he's trying to attack Judge Binkley still, or if he's attacking me, or what the direction of his ire is at this time. However, we submit to you that this matter arose, and this is a long litigation, as Mr. Fowler just kind of discussed, going on about 5 years now. I first got involved in the case when Mr. Burgess sought to bring Judge Binkley in as a party. He tried to amend the complaint. I believe it was going to be a fifth amended complaint. That motion was filed in the case, and the Supreme Court assigned Judge Roy Morgan to hear it, and I was retained to represent Judge Binkley in that. Judge Morgan denied that motion, and so Judge Binkley was not added as a party, and notably I was not added as counsel of record in the case going forward. Thereafter, it seemed like the case was had no end in the near future, and so I filed a motion under Rule 54 to render the judgment against Judge Binkley final, and I was under the impression that the case was still pending at that time. That motion was filed on February 23rd of 2024. Mr. Burgess filed a response pretty quickly after that on the 28th of that month, saying that a final order had actually already been entered, and so therefore the case was final and had finished its run in the circuit court. I immediately, within 11 days, filed a notice striking that motion, and then Mr. Burgess started filing a series of other motions seeking sanctions and other things on top of that. I did not set the motion for a final judgment for hearing, since I knew that Judge Binkley would not be hearing that for obvious reasons, and anticipating that the Supreme Court would be assigning Judge Morgan or some other senior judge or another judge in the state to hear the matter. It was ultimately heard by Judge Morgan as we anticipated. He denied Mr. Burgess's efforts to seek sanctions against various parties and to complain about the dismissal of Judge Binkley. And so we submit to the court that there is no basis to overturn what Judge Morgan has ruled in this matter. The plaintiff, Mr. Burgess, yes, sir.
What I hear you saying is you filed a motion to close out the case against Judge Binkley.
Only, yes, sir.
Only. And you filed it because you did not know there was a final judgment already.
That's correct.
That was because you hadn't been sent by anybody.
That's right. I wasn't counsel of record, and so I wasn't receiving anything from the court directly or from
And it was Judge Morgan who was doing that, not Judge Binkley. You were defending Binkley.
I was defending Judge Binkley in front of Judge Morgan, but
Right. So it was a final order Judge Morgan would have entered.
well, I think the final order that we're talking about was entered by Judge Binkley after
Okay, I got
Judge
you.
Morgan granted our I guess objection to trying to add him as a party.
Right.
And then Judge Binkley, without my knowledge, ruled on the rest of the case that was still pending in front of him.
Okay.
And then we filed the Rule 54 motion to trying to get Judge Binkley dismissed without knowing that the final order had been entered by Judge Binkley to the main case.
Okay,
itself.
he never told you.
He did not, Your Honor.
Okay.
And so, I mean, it had been pending for 5 years. I didn't know that it happened. And so, and as you can see, within 11 days of us receiving notice through the response of Mr. Burgess, we struck the motion. And so, if there's a grounds for sanctions or anything like that, this doesn't meet that standard, under the Supreme Court's rulings and, Tennessee Rule of Civil Procedure 11, that there's a procedure that sets forth, as the court noted a little bit earlier in the original part of the argument. There's a 21-day safe harbor provision that's set forth there, and Rule 11 sanctions are only allowed if if it's finding that there's that the matter was pled with improper motive or had no basis or was frivolous. And frivolous has been defined as having no merit in the law or in law or fact. And so we submit that there's nothing there, and even if there was, we struck the motion within the 21-day period. And so,
Counsel, you've used your time.
thank you very much, Your Honor.
Thank you. Hear from the appellant in rebuttal.
Well, first of all, Your Honor, I'd like to respond to Mr. Fowler. He clearly filed a motion to dismiss regarding me saying that the fines were illegal, which Judge Binkley affirmed that the fines were illegal. Mr. Fowler filed a motion without any support. That motion to dismiss, saying that they had the authority to, was untrue in its face. There's nothing in the CC&Rs, and you don't have to take my word for it. Judge Binkley says it in his final order. In addition, I think he's alluding to mootness, but mootness is not available here. I attached it in my brief. The HOA is still trying to fine me for signs in my yard, even though it's been declared that by Judge Binkley that my house complies with the HOA's CC&Rs.
The same signs or other signs?
The same signs.
Okay.
I heard him raise an issue. He's never raised any issue of litigation immunity. He never argued any of those things. He's never truly presented any compulsory counterclaim, never filed an answer. I can argue that statutory construction of 1615-732 will require him to spell out his compulsory counterclaim, because there's no way to make a determination whether or not it actually is, because he sought damages, which the CC&R doesn't cover. He sought injunctive relief. He wouldn't be possible, because again, they were ultra-virus. And he said declaratory judgment. The Declaratory Judgment Act can't happen, because in order for him to declare something against me, they would have to add all the members and join all the members of the HOA, which they did not. Also, to make it clear, I never sought declaratory judgment. I sought injunctive relief because they had already fined me. I was asking for the court to refrain them from finding me and leaving me alone, so to speak. In terms of Mr. Cole, he can't have it both ways. He can't not be a party, because if he's not a party, they didn't have standing to ask for a final order. And since he was also made sure he wasn't counsel of record, he can't then actually expect to be served the documents. And if you guys are listening to the same things I'm listening to, he's basically admitting that he filed blindly without checking the status of the case. I don't understand how he can be representing the judge and not know what the judge did. I don't know how he even filed the second motion without having the judge's authority to do so. That's my rebuttal. Thank you.
Thank you. Excuse me. Let me make sure. I just want to make sure you understand the procedure. You may already know this, but we'll take the case under advisement, and then we'll arrive at a decision, and we'll issue a written opinion on it, and we'll send it to you and the council over here at the same time.
Thank you, sir.
You would
Close the court. Yes, sir.
you would adjourn court to our next regularly scheduled docket.
All rise.